Come to learn laws, where knowledge is power, not legal advice, just for education. Need real counsel, don't roll the dice. Always speak with a licensed attorney.
Welcome to Learn Laws. We're here with Andrew Easler and Joe Reilly. Joe Reilly's from National Drug Screening, and he's a friend. I guess I've been friends with you for, I would say 10 years now, right?
Did you say, is he a friend?
Is he a friend? I think you're a friend, Joe.
At
I
least
would
10
hope.
years, yeah.
Yes, at least 10 years. So it's kind of interesting how we met. Anyways, Joe, why don't you tell us a little bit about yourself, and then we'll get into drug and alcohol testing and Methylene Blue, the hot topic as of late.
Sure. Again, I'm Joe Reilly. I am the president of National Drug Screening. I also have a firm called Joe Reilly and Associates Consulting for drug and alcohol testing. I've been in this world now for 31 years. So kind of dove into drug and alcohol business 31 years ago, and been riding that wave all along. Originally from New York City, born and raised, and moved to Florida about a year out of college.
Oh, wow. So what year was that?
It's like 1981.
1981. I wasn't even born then, Joe.
Yeah. So I've been in here in Brevard County for a long, long time.
Wow. You probably have shoes older than me, huh?
Yeah. My wife just threw away a scarf that I've had for 50 years.
Oh no!
Oh, my
wow,
gosh.
wow, that definitely ages you. Okay, so what made you get into drug and alcohol testing?
Yeah, well, interesting story. Back in the early 90s, I was doing consulting and training work for the hospitality industry, restaurants, bars, anybody basically with a liquor license, and we did programs to help them not lose their liquor license.
Ah,
If you're in hospitality and you lose your liquor license, you're out of business.
of course.
And back then, the state of Florida had really high workers' comp rates, and everybody was complaining about workers' comp rates, especially all our bar, restaurant clients, country clubs, hotels. And my partner and I at the time, Florida had passed a law that said, speaking of laws, and this is a legal show, right?
Yes, learn laws.
Florida had passed a law that said if a business implements a comprehensive drug-free workplace program, the state would mandate that the insurance companies give them a 5% discount on workers' comp.
Ah, okay. So there's the
And,
incentive.
my partner and I thought that was a great idea to help businesses comply with a law that would benefit them. And so at the time, we started what was called Florida Drug Screening. And we contacted all our hospitality clients, and only 2 of them were interested because they said if they drug tested, they wouldn't have any employees, which wasn't true. But we did have a couple of our clients jump on board, and they were very satisfied and very happy that they took advantage of it. And then we realized that we needed to go after construction companies and roofing companies, and we didn't even know about DOT when we started that business.
You just did mostly non-DOT.
Yeah, we didn't even know DOT was out there, and then we got a call from like the local UPS depot that wanted us to test their drivers, and then we got FedEx, and then
Kind of history.
Then we had Brevard County Probation come in, and so it just kind of evolved from there.
Wow. So that brings me to my first question, Andrew. What is the difference between DOT and non-DOT? Because I don't think, as Joe just said, a lot of people don't know the difference. And with our training company, we get a lot of calls where people are like, hey, I want to do drug and alcohol testing. And then my question is, well, would you like to do DOT or non-DOT? And then I have to go and explain this 10, 15-minute speech about what the difference is. So that's why I thought that would be a good first question for the podcast today.
Yeah, so it's certainly very nuanced. There's a lot of subparts to that answer, but the basic answer is DOT refers to the federal regulations. Most people refer to it also as the HHS regulations, even though they're 2 separate agencies. But the DOT sets a bar for safety-sensitive employees to make sure that they're complying with the drug-free workplace policy that's implemented by Congress, to make sure that our transportation, airways, railways, roadways are all safe from people driving very dangerous instrumentalities, as we like to use in the law. So outside of that is the non-DOT, which is basically everything else. So everything that's going to be under a company policy or under state law, like we were talking about earlier with Florida Voluntary Drug-Free Workplace Act, that would be a non-DOT type policy.
Okay, and then what's DOT or non-DOT? Sorry,
Yeah, so the non-DOT is everything that's not federal.
not federal. Okay,
Yeah.
so like what would that cover? Like maybe like an office worker.
Yeah, it could be office workers, really a forklift operator, anybody that's in a position that's covered by a drug-free workplace policy.
Yeah.
That is not also being tested under a DOT. And
So-
it could actually be both DOT and non-DOT.
So they could be both. So what is harder, Joe? Is it DOT urine or DOT drug testing in general harder or more comprehensive than non-DOT? What's the toughest?
Well, I think that one of the big differences is that the United States Department of Transportation (DOT) regulates certain types of businesses, as Andrew mentioned. Airlines, trucking companies, bus companies, oil and gas pipeline companies, and those companies are actually required to have the drug and alcohol testing program and required to follow certain rules and regulations. There's an overall rule 49 CFR Part 40 that tells us how we do drug testing. And then there's different agency rules for the different types of agencies, different types of employers, whether it be airlines, trucking, federal transit, federal railroad, U.S. Coast Guard. And those agency rules tell who to drug test and when to drug test. And then some other nuances like required employee education and required supervisor training. So that's somewhat difficult, but it's laid out for you you know what you have to do.
Yeah.
Where non-DOT, there are states that have laws that say this is how you do it, and there are states, as Andrew mentioned, like Florida, that has a voluntary program that you can participate in and get a discount on workers' comp. And so that program lays out what you need to do. But in the absence of a specific state law or a specific voluntary law, it's kind of like companies do whatever they want to do, and that could get them in a lot of trouble.
And that's where, experts, subject matter experts, drug-free workplace attorneys and so forth really help companies, right? Avoid penalties, liabilities, and contribute to like a safe drug-free work environment, I would assume, right? Am I correct?
Yeah, we have two potential areas of liability that we assess, right? So we want to make sure that, number one, employers have a safe and productive workplace, right? That's the number one goal. We want people to be able to come to work and not be worried that a rack is going to fall on top of them because somebody came to work under the influence.
Yeah.
So number one, we're here to try and mitigate those safety risks. By making sure that if somebody does have a substance use and abuse problem, that they're mitigated, right? That we can detect it, that we can address it, and hopefully get them the help that they need. The second type of liability we want to protect against is civil liability for wrongful termination cases or discrimination cases, because that's another huge set of potential liability. If we end up terminating someone for a lawful use, let's say they're on a prescription for Adderall, and their drug test shows up for amphetamines. Well, just because they show up for amphetamines doesn't mean that they're violating a drug-free workplace policy if they have a prescription for an amphetamine and their use of that amphetamine is consistent with that prescription. So we want to make sure that those people are not being discriminated against under the ADA. So it's kind of important to make sure that somebody's there to help guide you through those regulations and not run afoul, especially when there's not necessarily a clear, dark, black and white line, particularly when it comes to non-DOT programs. Would you agree, Joe?
Yeah, absolutely. And sometimes HR managers have a tendency to play lawyer or to play doctor, and they create a drug testing program that has exposure to liability. So, for example, there is instant urine drug testing available where you can get a drug test result in 5 minutes.
Oh, wow.
But if it's negative, it's reliable. But if it's not negative, it does need to go to a lab for confirmation testing and then to a medical review officer or an MRO. And that is a licensed physician that deals with the prescription, like Andrew mentioned, like if someone is on Adderall, legally prescribed, that's not a workplace violation. And if they only did that instant test and didn't do that confirmation process, and they took adverse action against that employee, that's where that liability comes in. And I tell employers that if you get sued, you're going to lose every time in that situation.
So what are the penalties? I mean, I guess they're all over the board, right? As far as if the civil liabilities.
Yeah, so I'll take that one. Yeah. So there are some fines if for example, if you have voluntarily joined a drug-free workplace policy that's mandated by an organization that's overseen by a government agency, they can issue fines. But the fines are usually pale in comparison to the kind of civil liability you're going to get in a judgment against you for a civil rights infringement. Let's say we have other claims like intrusion upon seclusion and privacy claims when you're dealing with things like direct observation.
Yeah, I could see that. I could see that definitely being a big issue. So my topic today, because I'm taking this as well, sorry, is methylene blue. This I'm hearing a lot of. Everybody's talking about it lately. I've taken some supplements, and I find it works pretty well for my mental clarity. So what is methylene blue, and why do you think it's gaining popularity in this space, Andrew?
Yeah, so methylene blue is it's touted as a miracle cure for a lot of different issues.
Yeah.
It was originally developed by a German scientist to dye some clothing. It was a clothing dye that was synthetically manufactured, and then another scientist in Germany saw its capability and use for studying cells by dyeing them and watching what happens and where the dye goes. And then eventually it started being adopted because it has mild antiseptic properties in other types of medical procedures like monitoring human body processes. So it's over time, there's been more and more research, and it also indicates it can be used to treat things like bladder infections and other things.
Yeah, it's a pretty cool. As I was doing more research, it's becoming more and more appealing to me. Just because of all the benefits. Now, again, I'm not a doctor and these are alleged benefits, right? Obviously, everybody's going to react differently to this stuff. So the reason why I brought this up was because I was peeing and my urine was green. And I said, oh my God, why is my urine green? And then I thought about the blue dye and then the yellow urine. And then I said to you, wouldn't this cause a direct observation based on what I know? And that's where this topic of the show came from. So would taking methylene blue cause a false positive?
Okay, well that's a very loaded question.
Yes,
right. So let's back it up and break it up into a couple different parts. So methylene blue is very, very blue. It's a very common dye that's used to dye a lot of different things because it has a very stark blue color. The body cannot process it directly. So when it goes through your bladder system, it doesn't change color like most other substances. So when it gets released from the body, it's going to tint your urine some kind of blue color. How blue it's going to tint it is going to be dependent on how much you're consuming.
Got you. Okay.
So assuming that it does come out with a fairly green hue, it's going to immediately let your collector know that there's something not normal about this collection. And that's something that's outlined when we're talking about DOT protocols under the 49 CFR Part 40.65. And that just tells the collector, hey, if you see some kind of color that's not normal human urine, you got to follow these processes for direct observation.
So what's a direct observation, Joe? Because I know this is, again, there's a lot of different, is there different ways to do direct observations or is there just one specific protocol procedure?
Well, under DOT regulations, there's one specific way. And then under HHS regulations for the federal government employees, there's another way. And then for non-DOT, non-regulated, it's really any way, but I advise people not even to do it because there's no regulatory authority to do a direct observation in a non-DOT situation.
Oh, wow. So you just tell them not to, so you just tell employers not to do it?
That's my advice. Other people may have other
And why is that, though? Why would you not perform a direct observation in a non-DOT setting?
Well, my advice, and I'll turn it over to Andrew from a legal point of view, is that, you're going into a closed bathroom with somebody and you're asking them to drop down their pants and pull up their shirt and turn around, and you're watching urine go from their body into a cup. And that's, it's embarrassing. People might claim things happened in that closed bathroom. And I'm not a lawyer, but They might say this was an unfair search and seizure.
Oh, wow. So
Let
there's
me
all
turn
these.
that back over to Andrew to talk about.
So that could be pretty, that could actually be, so if you have, so just, off the top of my head, so if you're doing direct observation and you have one of these claims, right? Oh, this person, illegally searched me or they intimidated me, especially if that person is under the influence of drugs, right? That could lead to a lot of problems, especially if that person's about to be fired for drug use or abuse or whatever, that termination is for. That could open up a big can of worms for a lot of employers.
Yeah,
right?
I don't know that it has to be someone that's using drugs. It could be anybody that just feels threatened by that process. And with DOT, you have to do it because it's a federal regulation. But with non-DOT, there's really no authority telling you to do it.
Oh, wow. So yeah, non-DOT. So what would you do in that situation, Andrew? Would you suggest that there's indirect observation, or how would you handle that?
Well, there's obviously some competing points here, right? So what Joe says is absolutely correct. There's almost every single state has a common law right of action for privacy intrusion. So if you break into my house and film me while I'm sleeping, that's a privacy invasion, right? And I can basically sue you for any kind of damages and harm that I've experienced as a result. That's the kind of claim that would normally be brought under a non-DOT protocol, where you force someone to observe, be observed urinating into a cup. Now, the counterpoint to that is, of course, just the same reason the DOT allows it, is that, hey, we want to make sure that if you're in a safety sensitive function, at least, there's nothing that's going to interfere with or tamper with the test. And so we're justified in protecting our workplace safety, health and safety, in violating potentially that privacy right of yours. Now, constitutionally, you have to have a government actor in order to have a civil rights violation, like a violation of the Fourth Amendment. So if you're just a private employer and you're not testing under any kind of authority, like Joe had mentioned, like a government authority, now the question then becomes, do you have a right to do so? But if you're testing under a government authority, whether that's a state law or a federal law, then the question is, have you gone so far that you have intruded upon their privacy rights under the Constitution? We have a balancing test under the constitutional precedent. If a government wants to search or seize your stuff, they have to make sure that they're balancing the interests, and that privacy interest has to be weighed against the safety interest. And so, is there any less restrictive means to perform this drug test than to literally observe somebody urinating? And that's a big question that's starting to come up more recently, right? Because we have a new type of modality under federal law.
And that's DOT oral fluid, if I'm correct.
Yes, coming soon.
So it's been, I guess it's been coming soon for what, 10, 15? I mean, it's been a long time, right?
Well, for DOT, I think it was 2018 that HHS authorized oral fluid.
Yeah, they've been urging it since 2015, I think.
We're talking about, at least 7 years, maybe more. The biggest issue right now is that the assays used to do the testing and determine that the metabolites of a drug are present in the urine have to have a 510K clearance, and that's really holding things up. It's a pretty tedious, sophisticated, difficult process to get a 510K clearance.
Wow. Hey, do you mind moving your mic up just a little bit closer to you?
Sure.
Just so, that's a little bit better. Yeah, that way we're not going to get a bunch of echoing. So, okay, that's very interesting. So getting back to Methylene Blue, because this is really my topic of the show, because I'm on this stuff. So I have a bunch of questions to ask you guys, because you guys are the experts. Do you know how long Methylene Blue lasts in your system? Based on what I've, I don't know if you know, but based on what I've experienced, probably, 5, 6, 7 hours. Then it starts coming out of my body.
I'll take that one.
Yes.
So first of all, we're not doctors, we're not scientists. We haven't conducted any of these studies.
Yes.
But the studies that have been published are showing that it can show up in your urine anywhere between 4 and 24 hours.
Oh, wow.
So and it can start changing the color of your urine pretty quick after your ingestion.
So that may result in a direct observation. Now, would that result in a non-negative or positive drug test?
Well, when you get a blue or a green specimen, typically or always in the past for DOT, you had to move to a direct observation because there's actually blue dye in the toilet bowl. and in the toilet tank.
Yes.
And the purpose of, if it's blue, they might have scooped some water out of the toilet or the toilet tank. And now if you walk out, James, with your specimen cup and it's blue, and you might say, well, here's my what is it?
Methylene Blue. Yeah, Methylene Blue. Methylene Blue. Amazing stuff.
That doesn't mean that you took methylene blue just because you say you have a bottle
Yeah.
of it and I took it. So a collector's going to look at it and say, well, the regulations tell me that if the specimen looks abnormal, specifically blue,
Yep.
I have to go and do a direct observation. So my advice to anyone taking this product that is subject to DOT drug testing is, if you know you're going to be getting a test done,
Don't take it.
don't take it. But if you took it this morning and you got popped for a random test this afternoon, you're probably going to end up with a direct observation. And I'm concerned because this is all fairly new, right?
Yeah.
This product.
Yep.
Yeah,
So
it's
if
been
you
around
did-
for a while. It's been prescribed for some limited circumstances.
Yeah.
But
I think
it's
the
now being popular
adoption-
over the counter, no prescription.
Yeah, I think the
And that's probably
adoption's
the bigger
relatively
thing.
new.
So you came out with a blue specimen, you go back in under direct
Yeah.
observation, and
Yeah.
you still have a blue specimen.
Yeah.
Okay, but the collector knows it came out of your body, so they send it to the lab. I'm not so sure that the lab is going to be concerned, Andrew. What do you think?
Yeah, so the lab, they have to follow the NLCP standards and make sure that they're following the rules when it comes to that. And so HHS, Department of Health and Human Services, kind of sets the rules and the certification. And so when they get it, they're first going to look at it and say, whoa, this is not normal. Right?
Yeah.
And they're going to look and see if there's any remarks that were provided on that original CCF, the custody and control form, and see what the reason is. If there's no remarks in there, then they're going to automatically cancel that test, because that's not normal human urine, and the collector should have known that that's not normal for human urine.
So that could be pretty catastrophic for both the employee, employer, and the specimen collector, right?
Well, a canceled test really should have no negative consequences on the donor, the individual who was being tested. It's really going after the collector for not having done it right, not having seen the problem in the first place. But assuming that they did the right thing and put remarks in that CCF, then the laboratory will have to make a determination as to whether the color is so strong that it interferes with their colorimetric testing. So they have assays that they have to do for a specimen validity to make sure that the specimen is real human urine, and those are based on color charts, right? So just like you when you're a kid in school science stuff, you had little pH.
Those
spectrum,
testing strips.
little testing strips, and they change color. The problem is how does the methylene blue affect the interpretation of that color? And if it's a pH test, does a strong blue color bring that pH down or bring it up? Will it interfere with their ability to test that? If they find that it is impossible to run that test to determine whether it's valid or not because the color is so strong, then they have to make that result an invalid test. And after an invalid determination, it goes to the medical review officer to make a determination as to whether that invalid is medically justified.
That makes sense. So who calls? So I hear this term TPA, or third party administrator. So if your urine comes out green or blue or whatever color it comes out of, that's not what we call normal, I guess. Who makes that determination to do the direct observation? Is it the specimen collector directly? Like, do they do it on the spot? Or do they have to call a TPA and have like approvals, or what's that process like?
Yeah, so TPA is a third-party administrator, which is a business like mine that is helping employers manage their drug and alcohol testing program. But a collector that's collecting urine specimens, particularly in the DOT arena, has been thoroughly trained and qualified, and they make the decision based on the urine that they're looking at that to them appears to be normal. They've never seen or heard of blue urine before, even though, because it's interesting. I was in New York doing a training 2 weeks ago, and for a big organization, and the head guy in the organization was telling me that he's peeing blue because he was using this stuff.
Isn't that funny? Yeah, it's catching on. It's very popular.
Anyway, we may come, the collector makes the decision. They don't call anybody. It's not the employer. It's not the TPA. It's the collector themselves. And as Andrew mentioned, it's going to be key to say, okay, first specimen blue, second specimen under direct observation, and donor claims to be using this product. And so a lab could see all that and say, okay, that makes sense. But as as Andrew was mentioning about pH levels and things like that, it still may come back invalid potentially. We don't really know yet. There's not a lot of these that have gone to the lab yet, but an invalid is not an employee violation.
Got you. So if your test becomes invalid, then you still technically would keep your job. You couldn't get fired for that.
Well,
generally speaking.
Well, yeah, but some companies that aren't too smart might fire somebody for that. Just like I've heard people firing somebody because they have a dilute specimen.
Right.
Crazy.
It's not a violation to have, that you drink a lot of water.
That's crazy. Wow. Yeah. So that could open up a lot of liability. So see, what I find about drug testing is most people think the industry or the process is a very simple process, right? I pee into a cup, I get my oral fluid, whatever you want to call it. And it's actually a lot more complicated. There's a lot of nuanced laws and regulations and rules that come along with doing drug and alcohol testing for both employers and the collectors, right?
Absolutely.
That's very interesting. So how the TPA, so the TPA doesn't do like a call for a direct observation. So how do they keep, so what really is a TPA? Let's start with that. I think we might have answered that a little bit in our last question, but let's go a little bit deeper with what is a TPA, and then how do TPAs keep the drug testing process fair? Because I'm sure that anybody that's partaken or has had to do a drug test, they know what a TPA is. Would most employees know what a TPA was?
No,
do most
not
employers
really.
do?
No. Employers will generally know, but maybe not. Okay. So the TPA is like an administrative management company. Okay. And first, they're going to help the employer that they're working with have a policy. And if they're DOT regulated, does that policy comply with those DOT regulations? If it's non-DOT, are there any state laws that need to be addressed in that policy? Like, for example, in California, you cannot use urine for a marijuana test.
Isn't that crazy? How laws have changed, and they seem like they're changing so dramatically now. It's like one administration to the other, or one policymaker to the other policymaker, and I feel like there's whiplash now, and there's not really a lot of guidance anymore. Like there's guidance, but I feel like people are unsure of the guidance now because there's not really a lot of case precedent.
And that's why you need a professional TPA as an employer, because the TPA's job is to keep up with the laws, rules, and regulations and best practices. So the TPA helps with the policy. They provide lab services as a third party. They provide collection services. They find collection sites for an employer wherever they're located. The TPA hires the medical review officer, the licensed physician that reviews the results. The TPA has software that provides the final result back to the employer through a lot of electronic integrations with the lab and the MRO. And the TPA will also manage, which in DOT required random testing.
Yep.
And also potentially consortium random testing, which is where you have small companies grouping together to do a larger pool of people for random testing. And the TPA answers questions every day, like you mentioned, all the different nuances and the waves of these laws. Employers call up and say, well, this happened, what do I do? Because they don't know. It only happened to them once. But as a TPA, we're hearing about it over and over again. We're probably going to start hearing about
Methylene Blue.
Methylene Blue.
Yes.
And what do? I got blue urine here.
What do you do with the Methylene Blue, right? It's almost like CBD. Remember when CBD was very it's still popular now, but do you remember when it first came onto the scene and people were getting positive drug tests or non-negative drug tests all the time? And
they still are.
Are they really?
People that take CBD often get a positive THC because there's THC in it.
That's crazy.
And it's only supposed to be at a very low level of 0.02%.
But nobody knows what's in those gummies.
But nobody knows they're not regulated. We bought those products and tested them. They had 10% THC in them.
No way.
Yeah. Wow. So we tell DOT regulated employees take CBD at your own risk, because when your urine has the metabolite of THC in it, the lab doesn't know that it came from smoking a joint or from taking a.
They just know you got THC in your system.
They just know there's THC in your system, and you violated the law.
Wow.
Correct.
So what is the DER then? Because we see third party administrators and then we see DERs, and so that would be, based on my research, it's a designated employer representative, right? So Andrew, what is a DER, and how do they interact with TPAs?
Yeah, so the designated employer representative is the person who's in charge of the drug-free workplace policy at the organization. And it is not the TPA. It cannot be the TPA, and this is something the DOT has had to clarify probably 10 times in your lifetime, right, Joe?
Because everybody wants to hire the TPA to be their DER, and it has to be someone employed in the company.
So it has to be an employee of the company.
Correct.
Oh,
Usually
wow.
a high-level employee. Sometimes people in smaller organizations will have the HR person. It could be the owner of the company. It could be a safety manager. It's really whoever you trust to be in charge of running that system, knowing the policy, knowing the law, and knowing who to ask when there's a big problem that they don't know the answer to.
So how many DERs does a company generally have? Is it like one DER or is it multiple?
Depends on the company, the size of the company. So most companies, it's one DER, maybe two. But bigger companies like, JetBlue Airlines, they have
Yeah.
like 5.
Oh, wow.
Because they're big. They have a huge population. They're all over the country.
Yeah.
Typically, you should have at least 2. But there should be a backup.
Obviously, I
because
would think so,
the
yeah.
DER has to be available at all times to answer questions over the phone. And if the DER is on vacation that day or at a wedding on a Saturday night, who does somebody talk to if there's an issue? Who does somebody talk to if there's a drunk driver that, just blew a .20 alcohol? You can't let them drive home.
So what happens if you can't get a hold of a DER?
That's a problem.
It's a big problem.
That's a big problem.
Because what would happen if you what are the consequences for the company and the DER, and maybe the employee too, right?
Liability, right, Andrew?
Yeah, huge liability. I mean, so if you don't have a DER available,
Yeah.
it depends on the circumstance, right?
Yeah.
There could be a situation where you need to notify the DER, hey, we had to do a shy bladder. That's probably going to have very little consequence if you can't get a hold of the DER to let them know that. Okay, but if you have a situation where you need the DER's input, hey, I'm having a circumstance where I believe that this should be considered a refusal, let's say, right?
Yep.
And I need the sign off from the DER, and the employee is still sitting in front of me. They haven't left. They don't want to leave. They want to cooperate, but what they've done seems to indicate that it should be a refusal. The service agent, that's the person that's running that part of the process,
Yeah.
would have to contact the DER and get their approval. So the DOT has clarified in their recent updates that the collector can't make that refusal determination on their own. It's always ultimately up to that DER to make that determination. And so what do you do as a collector? You just sit there and wait for the DER to call you back, or wait for the employee to just get up and leave?
So what generally happens? The employee just gets up and leaves.
A lot of times. But I think a bigger problem also is, particularly, as I mentioned, the example of an alcohol test. So the person blows into the breathalyzer and they're clearly intoxicated. What do you do with that person as an alcohol testing technician? And you can't get a hold of a DER at the company. You got to maybe try and call someone else at the company, maybe the president of the company or somebody, because you now have an intoxicated person in front of you, and it may be a 45,000-pound truck sitting outside.
Yeah, that's a huge safety issue, right?
And at times, you might even have to call the police.
So how often does that happen, Joe, in your practice?
It doesn't happen tremendously often, but it's
Yeah.
kind of like, how often do you have a fire?
Yeah, when it happens, it happens, and
When,
it's
when you have
damaging.
one, you got big problems.
Yeah, of course. So what happens when, okay, so methylene blue, I'm not sure if it would show a non-negative or positive on a drug test. I would assume it would show if it did go to a direct observation and you peed out more green urine. What would the lab do then? Would the collector would document that on the form, right?
Yeah, if it's well documented, the lab is likely going to test it. Okay, now, again, I'm not a scientist. I don't know if the lab is going to get an invalid or a negative or a positive.
So we don't know. That's kind of up in the air.
Yeah, so
if they get a negative, it's negative.
Yeah,
If
negative,
they get a
yeah.
positive, it's positive.
Then we have problems. So what happens when an employee fails a drug test then?
Well, so right now there are some studies that have already addressed potential false positives
Yeah.
for methylene blue, but there's a wide range of substances and metabolites that we test for on our drug test, and there simply is just not enough research to necessarily rule out the possibility of a positive drug test as a result of taking methylene blue, right? There's some magic chemical reactions that are going to go inside the human body that we don't know for sure isn't going to somehow fool the test into thinking it's some other kind of substance. That being said, if somebody does show a positive on that lab test, let's say they move forward, they're okay, doesn't affect the colorimetric testing,
Yeah.
they get the quantitative result, which is basically saying, hey, there's this particular concentration of metabolites we would normally see if somebody's taking THC, for example. That result is going to go to the MRO. and the medical review officer, that MD or DO, specifically trained on reviewing these results, is going to contact the employee to try and find out if there's a medical explanation for this positive result that they're getting.
So how does an employee dispute? Because I know on our YouTube channel, we get tons of comments. I mean, this is like one of our top comments.
That's a great question because the MRO isn't going to overturn a result because of a supplement. Okay, they can't verify that you took it or didn't take it or that you took something else. I mean, they overturn a result based on a legally prescribed prescription. So the recourse to the employee, okay, they tested positive for cocaine, and they say, well, it was caused by methylene blue. The recourse is that they can have that specimen sent to another lab. They keep, it's a split specimen process.
Yeah.
The specimen is sent to another lab to find out if the first lab made a mistake. Typically, the second lab comes back with the same result as the first lab. And right now, in a DOT program, that person is going to be a violator. And if they're a truck driver, they're going to be reported to the clearinghouse. They're going to be prohibited from operating until they go through a return to duty program with a substance abuse professional, or SAP, as we call them.
So that can get pretty complex and complicated for everybody involved, the employer, the employee.
Same thing with the CBD issue. Guys are going to a substance abuse professional because they took
that's crazy.
They took CBD, but that's what
crazy.
the regulations say.
So what rights do employees have then, as far as, okay, they got tested positive for CBC or CBD, maybe some methylene blue, I don't know how that even comes out on a drug test, but say, it's a positive, right? What rights do they have, legal rights do they have for non-negative? And I'm non-negative, right? So I'm sure if it's a negative, you're going to have no problems. It's just,
no questions.
You move on with your day.
We all move on. Yeah.
Okay,
Nobody wants to confirm a negative.
Okay, so positive. What legal rights do employees have to dispute those? I think we briefly touched on it, but I need to. I'm still a little confused on what legal rights I would have as an employee if there's a positive.
Right. So the very first opportunity you have to start contesting a positive result is when the medical review officer contacts you.
Yeah.
So you're going to get a positive result. The medical review officer is going to call you up and say, hey, you got a positive for amphetamines. Is that a surprise to you? Do you have any medications? Do you have any prescriptions? What are you taking? And then that's your opportunity to reveal whatever medication, supplements, over-the-counter, anything that might possibly explain that result. And then the medical review officer takes that information and utilizes his expert knowledge and training to determine whether or not those things that you're taking could have resulted in that particular positive, and that those things that you are taking are validly and lawfully prescribed by a physician and dispensed properly by a pharmacist at the right dosage. So if there's a mess up by the medical review officer in that process, let's say, he was not aware of a potential medicine that could be causing this result, which is one of their jobs, right? The medical review officer is supposed to stay up to date with the research to determine if there is something out there that could potentially cause one of these results. But let's say he made a mistake.
Yeah.
Then, of course, you can contest that result and that determination. Now, you would have to get your own expert that knew the reason, right? You'd have to get maybe a PCP or another MRO, ideally, who specializes in this to reveal the medical information, show it to the MRO. Maybe the MRO may come back and make it change on that determination. Yeah. But it's a pretty lengthy and expensive process to do that.
So who's responsible for paying for those fees? Would it be the employee, the employer? Would it be like health insurance?
Typically, it's going to be the employee, because the employee is saying that you're telling me I'm positive for cocaine and I'm telling you that I took methylene blue and that's what caused it.
Yeah.
Well, the employee then has to go to court and prove that. So they're going to have expert witnesses and scientists and laboratory people. That on the other side, they're going to have scientists and laboratories.
Yeah.
And from the employer side or the TPA side is typically insurance that covers it. If you have, errors and omissions, professional liability.
Of course. You can always recommend that with collectors, right?
But the employee doesn't have that kind of insurance to cover that kind of lawsuit.
Wow. So that could, in a normal situation, Joe, what would the employee just basically get terminated and move on? Is that generally what happens in those situations? And they
don't always get terminated. It's up to the company policy. For DOT, they have to be removed from the safety sensitive position, and they have to go through a return to duty process with a substance abuse professional. And they could also be terminated, but that part's up to the employer.
Ah, okay. Gotcha.
For non-DOT, they could be terminated if that's what the employer's policy is, Or the employer may have a policy where they give them a second chance agreement that says, okay, you have to do this or go through rehab or talk to employee assistance
Yeah.
programs. And if it happens again, then you would be terminated.
So what happen in your ordinary course of business, in your practice, what generally happens?
It's about 50-50 on whether they terminate or let them go through a return to duty.
Oh, wow. So it's
process.
50-50. So it's up in the air, really.
Yeah, it kind of depends on, how high turnover is at the company, how much money they invest into the individuals, and, just the personal philosophy of the business owners themselves.
So how is the DER involved in this whole process as far as like an employee disputes the test? How is the DER involved in this process?
They're basically the spoke in the wheel, or at least they're supposed to be, right? So they're going to work in coordination with their TPA and trusted advisors to make sure that they're making the right determinations when these kinds of events happen. But ultimately, it's their decision.
Yeah.
They're going to take on that liability if they make the wrong decision for the company.
And they're going to call their attorney to help defend them.
Right.
So that being said, how common is drug and alcohol testing in the workplace in general? Because I know some employers, they don't test at all, right? They don't want to test because, as you said earlier, they'd have to terminate half their employees or maybe all of them, right? Especially like businesses like maybe moving companies, fast food workers and stuff. I guess, Joe, first of all, how common is drug and alcohol testing in the workplace, and what industries need more drug testing than others? Like, do you know kind of the...
Sure. So in DOT testing, it's mandated, so there's no question you have to do it. There's probably 700,000 employers in the United States that are DOT regulated.
Wow, that's a lot of
But
employers.
there's probably 100 million employers that are non-DOT regulated or more, okay? And so there's probably not 50% of them doing drug testing yet.
Yeah,
I mean, that's
probably
where, from a business point of view, that's what I call the growth of the drug testing business is the employer who's never did drug testing.
They don't know about it. It's not on top of mind.
But they see it on TV. They see it in the movies. They hear about it. Maybe a family member has an issue. Maybe an employee has an issue. And then that next day, that next Monday, they wake up and say, maybe I should do drug testing in my company. Or maybe they get a contract from a bigger company like Amazon or
And they require it.
AT&T, and that bigger company requires drug testing. So now they have to, or they get a federal contract which requires a drug and alcohol
Okay, that makes a lot
testing
more
program.
sense.
Now you mentioned moving companies again; those fall
Yes.
under DOT. So those,
Yes.
unless it's a small truck, those guys are
required.
to do drug testing. And another example, like with Amazon, they have the local delivery service
Yep.
guys that
Yep.
have their own little business, and they
Yep.
have 20 vans running around town. Amazon requires those guys to have a drug testing program.
Oh, wow. So we're talking about DOT drug testing in this context. How common is random drug testing? They have to be randomly drug tested, right? Is there like a frequency or a percentage of the employees? How does that work?
Yeah, so it's
Andrew?
every sub-agency of the DOT sets their own random testing rates, and they publish it, every year?
They publish it every year. They publish any changes, or it stays the same.
Right.
Yeah.
So those numbers are mandated by the DOT, and then usually a DER is going to outsource that responsibility to call those people from that random pool to a TPA who's going to utilize a scientifically valid random selection method, not the bingo turner, right, with all the little balls in
Not
it.
the deck of cards.
Not the deck of cards. They're going to use a program usually to run those numbers and then call those people out for randoms.
So what kind of drugs are tested? Because I know there's different panels, right? So I know there's like 5 panel, 7 panel, or 10, whatever that is. It goes up. How many panels? What's the maximum number of panels?
Oh, it could go. I mean, it's really rare, but you could probably test for 50 different substances. But
Oh,
it's
wow.
pretty rare. But for DOT, we're testing for a 5 panel, although some people call it a 7, 9, or 12 panel. So
Okay.
the 5 panel is marijuana, cocaine, amphetamines, which includes methamphetamines, and MDMA, which includes ecstasy.
Okay.
PCP or pencyclidine, which is pretty rare, but they still get positives. So they keep it on that DOT regulated 5 panel.
Yep.
And then opioids, which we're now adding codeine, morphine, heroin, oxycodone, oxymorphone, hydrocodone, hydromorphone. So if we counted all that up, we really got to about 12, but it's called a 5 panel drug test, DOT. And what we recommend to our non-DOT clients is that do what we call a DOT-like panel.
Yep.
Same 5 panels, same drugs. It's just not under the DOT regulations. We're probably going to see fentanyl. Fentanyl is going to be added to the HHS testing for federal employees as of July 7th of this year. And then DOT will look to adopting fentanyl also, but it will be under the opioid, so it'll still be a 5 panel.
So they've never tested for fentanyl before?
Not for DOT, no.
No way. You know, for having such a crisis in America for the last 20 years, I'm super shocked that that hasn't been more of like a priority for the DOT.
Federal regulations move very slowly.
Very slowly. Yes. Well, look at DOT oral fluid. It's been, 10, 15 years or something crazy. We're still kind of, we're not able to test right now, are we? I know the training's available, right?
Yeah, we need 2 labs that are certified by HHS. There aren't any labs certified yet by HHS.
I thought, wasn't there one that just got certified, or am I wrong? No?
No.
Wow.
There's one in Canada that's close, actually.
Maybe that's what it was, yes.
But not certified yet. And Canada doesn't have that FDA 510K clearance issue, so that's why they're probably going to be the first one. And that's the slowdown, really, is the clearance, the FDA clearance of the assays that are used to detect the metabolites of the drug. So if there are 2 labs certified it could be the Canada lab, it could be a U.S. lab, then DOT employers can start doing oral fluid testing.
So the labs have to be certified, so they could be a lab certified, say, in the Philippines, Canada, one in the United States, or is it just specifically to Canada and the United States?
It has to be SAMHSA certified.
Okay,
but it could be an out-of-a-country lab.
Yeah.
Like there's a lab in Canada that is currently SAMHSA certified for urine. Okay. There aren't any labs anywhere else in the world other than the U.S. that are SAMHSA certified for urine. So that's the first step. Okay. And then under the FAA regulations, the lab does have to be in the U.S. So they have a little nuance there that the lab has to be in the U.S.
Okay. Maybe an employees, maybe they're under the influence, maybe they're not. Can they refuse a drug test? And what happens if they refuse? I know we touched on that earlier, but can we go into a little bit more detail on that?
Sure. Go ahead.
You can go ahead, Andrew.
Yeah. So an employee, certainly anybody is free to do whatever they want. You know, it's a free country. You can
obviously
choose to decline to participate in a drug test, but there will be consequences, and those consequences will be outlined in the company's drug-free workplace policy.
So that just depends on the company, right, and what their policy is?
Right. And
they put it in their policy, and my advice to every company is if they refuse the drug test, terminate them.
Of course. I mean, why wouldn't you?
It'd be like if they refuse to follow a company policy that says you have to arrive at 9 o'clock and they arrive every day at 10 o'clock. Yep. You're going to terminate them, right?
Yeah, of course.
Yep.
Of course.
It's also a safety issue, right? If they can't follow simple instructions to, participate in a collection, why are they not going to be able to? What makes you believe that they're going to follow your safety instructions to operate whatever equipment that you're?
Well, I'll say something about being late, though. I don't know if I'd fire somebody for being late. Sometimes my best employees, Joe, are late all the time.
But if they're late every day of their life.
I've had people like that, yes, but they're so good you can't get rid of them. That's kind of the current work environment.
It depends on the business, of course. If the phone's ringing at 9 a.m. and no one's there to answer
there's a problem.
There's a big problem.
Obviously. So how does state laws affect failed drug tests, right? So we've touched on that a little bit earlier as well. So we have federal laws that affect, we obviously covered that. How does state laws affect that? Because you could be on the federal side, you could have a positive, or what we call non-negative, and then you on the state side, that actually, even though you're a non-negative, that might be, is that considered a negative? If you know what I'm saying?
Okay, so I think what you're talking about first, we should probably address is THC.
Yes,
and that's probably the thing that most people really care about. Yeah, and it's the hot button issue because it's very confusing the way the laws have decided to land.
And that's what I was getting at, the federal and the state stuff. Yeah.
Yeah. So right now, marijuana THC is Schedule 1 on the Controlled Substances Act, which basically means it is a crime to smoke or ingest or utilize THC. And because of that, most states are going to say, well, you have a right as an employer to prohibit illegal activity on your property or at your workplace, and therefore, even though we might have recreational or medical marijuana available under state law, you still have the permission under federal law to prohibit that criminal activity, essentially, the illegal activity. Now, not every state has taken this position. The state of Connecticut, in particular, has provided specific protections under non-DOT testing programs for people who are utilizing marijuana on a medical basis. So employers cannot necessarily take adverse action against an employee in that state, even though federal law says it's illegal.
So how would an employer even handle that from a liability perspective? That seems
It's very difficult, and but let's just clear up one thing. If it's DOT testing, it's a prohibited substance, and you violated federal law, and you have to suffer the outlined consequences, and the company will not take you back until you finish the return to duty process, if they even want to take you back.
Okay.
But then for non-DOT, the company has to look at where do they operate. If they only operate in one state, like Connecticut, they might want to drop marijuana on their non-DOT program, not even test for it.
And are a lot of employers doing that now, dropping the marijuana?
A good number, not overwhelmingly.
Yeah.
But, we see companies dropping marijuana. California particularly, because the California law is about 2 years old now, the AB law.
What is it, AB 12 something or whatever,
They're basically saying that, somebody smokes pot over the weekend and you test them on Tuesday morning, you're not testing impairment, and there is no impairment testing for marijuana. So they're saying if you use urine, you can't use urine.
So why even bother doing it?
Yeah, but you can use oral fluid.
But what's the detection time for that?
The detection time with oral fluid is going to be from ingestion going up 1 to 2 days. So it's much more likely with oral fluid, and they're testing both the parent drug and the metabolite.
Yeah.
It's much more likely that it's recent use that may have happened this morning.
Ah, okay.
Right. So much closer to impairment, but again, we don't have any physical impairment tests. And that's where some states have decided, instead of doing and relying on drug tests alone, let's look for signs of impairment. Have somebody that's specially trained on recognizing that.
New Jersey has a thing called a drug recognition expert that the employer has to have.
That's crazy.
To make decisions based on, okay, we're positive for marijuana. Do we also show signs of impairment as documented by this drug recognition expert?
Wow. Right. So this goes back to the importance of training. See, a lot of people don't realize, and I've experienced this being in this industry a little bit. Again, I'm not an expert here, but being on the outside of the industry, I see a lot of people not trained properly. And this is why we started worktraining.com.
Not trained at all.
Well, or not trained at all. And this is when we're talking about this, what this made me think about was there's a lot of these complexities and rules and regulations and nuances when it comes to this kind of, whether it's a drug-free workplace or drug and alcohol testing. And a lot of people don't understand the value of proper training. There's lots of trainers out there, Joe. You know this. You've been in the industry for 20, 30 years. Sure. And you've seen a lot of interesting people come and go, I'm sure. And, what bothered me was when we were starting worktraining.com for the training side of it, when he was a high school teacher transitioning to corporate training, he went to a company in Utah. And as a teacher instructional designer, he said, I called him, I said, how's the training going? He said, oh, it's going okay, but I can do a better job. And the training was just garbage, in all honesty. I think that's the way, Andrew, I think that's what you said. It was just garbage. We could do it better, and we did do it better. Just like when he became a lawyer, we were trying to find a lawyer for the real estate investment company. And, he looked at a lease agreement a local lawyer prepared. And he's like, this is garbage. I'm just going to go to law school part-time and do it myself. And that's what he did. So,
awesome. That's awesome.
Yeah, I just find that training is, especially for training in general, right, is obviously super important, right, to have a trained workforce or skilled workforce. But for drug and alcohol testing, because of all the liability issues, because of all the workplace safety issues, proper training is super, super important. And you're a great trainer, Joe. Same with Andrew. You guys are both great trainers. That's why I have you on the show to talk about this. So, Joe, quick question for you. If you're an employee, what tip would you give an employee when they're preparing for a drug test?
Well, stop using drugs if you are.
Of course, yes.
Okay.
Yes, that's the most important thing, I guess.
If you're taking a substance that might make your pee turn blue or green, you might want to discontinue that if you know the drug test is.
So in my case, if I take Methylene Blue, which I have, I love it, by the way, I should stop taking it like 24 to 48 hours.
Yeah, if you know you got a drug test on Wednesday, you may not take it until Wednesday, because not that you did anything wrong, but it's just going to complicate things. You got blue pee. People are going to freak out. They never heard of Methylene Blue yet.
Yeah. Yeah.
There's going to be a lot on there. I just shared with you a
Yeah.
LinkedIn post
Yeah.
from a collector up in New York who takes it also.
Yeah.
So he's
Right.
very familiar with it because he's taking it, and now he has seen a couple of instances of blue urine. So the other thing is not to drink an excessive amount of water. Okay, just
Yeah.
drink a normal amount of water, because if you get a dilute specimen, not that that's a violation or anything, but it may require you to go back. And so you're just like asking for problems.
It's just not worth the hassle, so just don't do it.
Don't drink a gallon of water on the way over to the collection site, okay? Don't have anything in your pockets that's
So
gonna-
don't drink a lot of water on the way to the
don't drink
collection
an
site.
excessive amount of water
because
Drink
people.
normal water.
So, and why would people drink excessive amounts of water before a drug
Because
test?
They're afraid they're not going to be able to pee on demand.
Ah, okay. Okay.
Which is the mistake they make. And then they get a dilute, and then their HR person doesn't understand what dilute means, and they're calling them in like drilling them like, well, you have a dilute, which they shouldn't be doing. Of course, they're
Yeah.
not trained they're not trained HR people,
Yeah.
DERs. But
Yes.
they're acting like this employee did something wrong. So
Ah, okay.
just eliminate that by not drinking an excessive amount of water. Just drink,
Yeah.
maybe a touch more than what you normally drink. And don't have stuff in your pockets that's going to be suspicious.
Of course.
Okay, just to not have any potential things come up, whether it's right or wrong.
Yeah.
Just go for your drug test. Cooperate with the collector. It's kind of like you get pulled over by the police, and you cooperate with them. Maybe you won't get a ticket.
They're just doing their job, right?
Just
So a
doing
lot of
their
people
job, yeah.
come in, they get upset with the collector, and they're just doing their job. So, respect them. Don't, be belligerent.
Yeah,
I
yeah. I
guess.
mean, a lot of people don't realize, they see him more as an adversarial party in this process, but really, the collector's main responsibility is to make sure that you, as the employee, have a right to a fair test.
Yeah.
They're there to ensure chain of custody and make sure that the document, your specimen, doesn't get mixed up with somebody else's specimen, to make sure that your specimen gets to the destination, it gets tested properly, and those results are properly attributed to you. What you don't want to have happen is a collector that's not following any procedures and then mixes your specimen up with somebody else's and then ends up the wrong way. So, they're your buddy. As long as they're properly trained, they're going to do right by you, and they certainly want to get that test done and completed as soon as you do.
Of course. Of course.
And one other thing that I would tell the employee,
Yeah.
if you get a call from somebody called the MRO, take the call right away.
So, what happens if you don't take the call right away?
Well, the MRO tries to call you 3 times over the first 24-hour period that they got the result, and you're not answering. You're not calling them back. The MRO then calls the employer and says, hey, I'm trying to get a hold of James, and, is James working? If he is, put him on the phone. Well, no, it's pre-employment. We don't know where James is. And then there's a little bit of a process, and with DOT, that could almost go up to 10 days.
Oh, wow. So that could be
So
pretty.
every benefit of the doubt is given to the employee in all cases, but particularly in this case, because maybe they're on a 9-day cruise.
Yeah.
Potentially.
Yeah.
So they are given lots of opportunities, but eventually, if they're positive for amphetamines and maybe they take Adderall and they have a legitimate prescription, the employer is going to get a result that says positive.
Yeah.
It's going to say no contact. That means the MRO did not talk to them. Now, if there's a legitimate reason why the person couldn't call the MRO back, they could call them at this point, and the MRO would reopen the case. And if there is a verification of a legitimate medical prescription, they would overturn the result back to a negative.
So how long would what's that time frame? So if you say if you're sick for 30 days or something in the hospital, right? You've done your test, they're trying to get a hold of you. Would they reopen it 30 days later if you could prove you were in the
If
hospital?
you were in the hospital for 30 days, I mean, every case is going to be different.
Obviously, yeah.
But you've already had 10 days pretty much.
Yeah, that's a long time for
Yeah,
somebody.
I mean, there's going to be some kind of indication.
It's
Usually
crazy though.
30
People
days
sometimes just
for
don't
sure.
answer their calls. I mean, it's just it's really
Yeah,
crazy.
that's a big thing, right? A lot of collectors I train are saying that they're telling the employee before they leave, hey, make sure to keep an eye out for this particular phone number, because the phone number for the MRO is going to be showing on step 1B of that form that they're going to get, or answer unknown numbers for the next couple of days.
So can MROs use text messaging, or does it have to be a phone call?
Well, they have to talk to them.
Okay.
Okay,
So
but they could
like
use text messaging.
hear
to
them
say,
physically, like
to call me.
Okay.
But they have to physically talk to them.
Okay.
And they may have to get like a copy of a prescription, or they're going to get the pharmacy's phone number and they're going to call and talk
Okay.
to the pharmacy to verify that you have a prescription for Adderall or whatever it is.
Okay, perfect. And then Andrew, one tip for employers. Obviously, we covered, make sure you have a drug-free work policy. If you don't, that's, I guess, the first, tip you'd have for an employer, right, Andrew? And then training.
Yeah, I think the important thing is speaking with, if you're developing a policy, changing a policy, or you're not 100% sure you're doing a policy correctly, talk to an expert.
Yeah.
Right. There's no one size fits all for this, and every business is a little bit different. We talk about, some employers are saying, well, listen, I'm scared that I'm going to get in trouble for testing somebody for marijuana. But on the flip side, if you have somebody who is part of a random testing program, let's say they're running a forklift at your company and they're non-DOT regulated, right? And they get called for a random test and you test them, but you don't test them for marijuana, and they get back on that forklift and knock over a bunch of racks, cause millions of dollars worth of damage, maybe worst case scenario, kill somebody. I mean, think about the types of liability that you now have.
Yeah.
You had the opportunity to prevent that.
And then they go to the hospital and have THC in their system.
Right.
Oh no, yeah, that could lead
Right.
to a lot of
think
severe.
about the family of that person who's now passed away.
Yeah.
Saying, well, listen, you had a responsibility to protect the workplace for my loved one.
Yeah.
And you were supposed to test him. You had an opportunity to test him. You tested him, but you decided to leave this out for whatever reason. And if that reason, according to a judge, is not good enough under state law, because maybe the state law hasn't done something like Connecticut, that's a terrible position. I mean, you're probably getting close to insolvency for that company.
Wow, that's crazy. One little mistake like that, or one issue like that,
With
right?
any type of safety sensitive position,
Yeah.
if you dropped marijuana, you are facing a liability situation for the reasons that Andrew just pointed out.
That's crazy.
It's
So if
different
you're,
it's maybe just all office people and you don't have anything else going on, that where there's not likely to be a catastrophic accident, but somebody's driving a forklift, working on heavy machinery, working with chemicals.
so those guys wouldn't be, so those employees wouldn't be necessarily covered under federal DOT protocols. They would be non-DOT, but you would recommend them not taking the THC side of it out.
Yeah.
Correct.
So to affirmatively say it, do not
Do not.
take THC out of your policy unless you are advised to do so by an expert professional
Or an
because
attorney,
of-
right?
or an
Obviously,
attorney.
legal advice. Always
Right.
get that kind of information or from an attorney for obvious reasons.
Right. We're not providing legal advice here.
Yeah.
But it's certainly, before you start dropping panels from any kind of test, whether
Yeah.
it's marijuana, cocaine, or whatever, right? Talk to somebody.
Yeah,
Right?
of course.
Get legal advice. Maybe get it in writing so that if something does happen in the future, if you are advised to take it off, you can at least come back and say, well, listen, I asked somebody who was supposed to know this stuff and I trusted their advice, and that's going to mitigate any kind of mens rea or negligence issue on your part.
That's
'Cause
very
you had a duty
interesting.
to investigate that, and
Wow.
hopefully you have
It
breached.
might mitigate that, right?
Might. Hopefully.
Because
Might.
if the box truck driver ran into the orphanage and 17 kids were died,
Well, yeah, I think you're gonna have bigger problems.
you're not going to have a mitigating
No,
answer.
no, I think you're pretty much out of
If
business.
he was stoned on marijuana.
Has anybody ever spent any time in jail for obviously for drug testing? If you kill somebody, manslaughter, I guess. But has an employer ever spent any time in jail for doing it wrong? Do you know?
An employer or
Yeah, an
employee?
employer or both. I guess an employee could easily spend time in jail if they on the job and they kill somebody or there's some sort of issue there. But what about an employer? Have they ever faced jail time for not managing a drug-free workplace policy properly or having?
Not that I'm aware of.
You know what I mean? Like liability. What I mean by
But
is there liability?
They could pay out millions of dollars.
Dollars, okay.
settlements
Yeah.
if-
Yeah,
if
okay.
they did it wrong. So,
Yeah, of course, of course.
And I've seen lots of people lose their jobs for not doing it correctly.
Yeah,
But,
DERs, yeah.
Yeah, DERs. And there's obviously some crazy civil liability. There's been some government agencies who have done some shady
Yeah.
things. Not the entire government organization themselves, but people. People are people.
Yeah.
And you get somebody that you don't like, and you decide you have the opportunity to start messing with some numbers and changing some results.
Very
and,
interesting.
And then it always gets discovered, and they always find out, and there's always a big lawsuit, and they always lose their job.
So I guess the takeaway from this show is proper training. Always consult or contact a professional in the drug and alcohol testing space. If you're going to take Methylene Blue, which I personally like it, but if you're going to take it and you're going to have a drug test, try not to do it before the drug test to avoid complications, right? Or direct observation procedures and protocols. And then if you do take it and you have a random drug test, let somebody know that you took Methylene Blue, and then make sure the MRO contact, or make sure you answer the call from the MRO. You said they try up to 3 times, and then after 3 times, they
call the employer.
They call the employer.
Tries to contact you.
Okay, perfect.
So
and then
they work together to find this person.
Yep. And if you were under the influence of other drugs, well, that opens up another can of worms. And then if you have to let the employee go, or the employer wants to keep their job, it's a 50-50, depending on what the employer chooses, right? And then after that, if the employer chooses to have them stay on board, would they go through a substance abuse program? Am I correct in saying that?
Yeah, if they had a violation.
That a violation, and would they still have to go through the substance abuse program even if their employer terminates them?
Well,
if they want another job.
Yeah.
Okay,
yeah,
under the DOT rules.
Under DOT, you cannot work in any DOT regulated position, DOT covered.
Unless you go through one of those
position.
programs.
If you violated any DOT policy,
Yep.
In order for you to get back into that position or that career field, you're going to have to go through an employee assistance program with an SAP.
I guess the takeaway lesson of the day is just don't do any drugs.
Yeah, so I was just gonna add, taking Methylene Blue is not a get out of jail free card if you use cocaine or heroin.
Of course, yeah, of course. Just don't. Yeah, those are obviously you're gonna have problems with those drugs, right? And anybody that takes those drugs probably knows or generally understands the consequences. They don't realize that they're going to be randomly drug tested. Now, is random drug testing pretty? I know the DOT has the rules, but is the random drug testing for non-DOT? Is there like specific requirements on the state level, or would that just be employer specific?
It's pretty much employer specific. There may be some state laws in minor instances, like maybe in the mining industry. I know there's one where they do require some random testing, but it's few and far
Negligible.
between.
Okay.
It's up to company policy, but not having random testing is like not having any teeth in your policy and your program, because it's kind of like you can study for a pre-employment test and pass it.
Yeah.
And then, well, unless you have an accident or there's reasonable suspicion, you're never going to get tested again. So if you're a substance abuser, you're going to continue to use, and that employer is going to continue to have a substance abuser on
payroll. Yeah.
And anything could happen. Anything, bad could happen.
Yeah, so it's best just to, so it's best to obviously do random drug testing. It's best to not do drugs, obviously, so everything comes out negative and people can move on with their day and enjoy their life.
Yeah. I wanted to add for the employer, they hire a TPA to help them run the drug and alcohol testing program and to give them advice and to give them guidance. But it's important to hire a professional.
Correct.
TPA.
We were talking, yes.
And so, ask the TPA, what are your credentials? Where have you been trained? I just did a training last month in Jacksonville for the National Drug and Alcohol Screening Association, where we trained 15 people how to be a good TPA.
Oh, wow.
So they could go back into their businesses, and now if an employer asks them, they could say, well, I went to this full day training class and I learned, and I have now a certificate that says I learned how to be a good TPA.
Yeah. So why would somebody, so I know with like Joe, you're a trainer as well. And Andrew, you are a trainer too, right? I think the nice thing about, you is you being in the business for a long time. You have a lot of, experience, a lot of different scenarios, a lot of stories. So you can help people mitigate potential liabilities that way and help them implement a really good drug-free workplace. And then Andrew, from your perspective, I think personally, having training from somebody that's either really, really experienced, that has a lot of industry knowledge and scenario training is good. But I also think it's important because you're dealing with a legal context, right? And this has been something that we've always, believed in, but because you're dealing with a lot of legal issues, a lot of people like training with you, specifically because you're an attorney and you're licensed in multiple states, or you're about to be, you are licensed in DC and Florida. I'm soon to be Alaska and throughout the Caribbean. You're just waiting on the bar application to be approved, right?
Yes.
Okay. So
Awesome.
Yeah, there you go. Congratulations. Andrew's a smart guy. So again, training, obviously use somebody that's experienced, has industry knowledge. And then if you're dealing from a legal perspective, obviously get legal advice from a licensed attorney, right? Because I notice in this industry too, a lot of people like to give legal advice as if they're a lawyer and they're not. And that causes liability. We've dealt with problems too in the past where we have, learners call us or training managers or CEOs of companies and said, hey, we had this, we were told on how to do our drug-free workplace from this person. And all of a sudden we say, well, were they attorneys? Well, no. Well, why would you take legal advice from a non-attorney, right? So it's good to get procedure and testing knowledge from somebody that's, an expert in their field and has a lot of scenarios because they could help mitigate a lot of risks. But it's also just as equally important, in my opinion, to work with an attorney at the same time to really make sure you have a tight drug-free workplace policy and you're limiting your liabilities on multiple fronts, right? That's just my opinion. So I think that's a pretty good process or protocol to follow.
Yeah, and
Absolutely.
I think one of the important things I want to address here also is, in terms of the testing, the largest brackets of people being tested.
Yeah.
Under DOT protocols, we're looking at the FMCSA, which are trucker CDL drivers.
Yeah.
And of that demographic, the largest group are owner operators, right? And this country runs on truck drivers, usually solo drivers that are driving by themselves. And so those people have to be their own quote unquote DER, but they can't also put themselves into a random pool because 100% of the time they're going to be pulled. So for those particular people, what is the important process, Joe, for them to know about working with a TPA and evaluating whether a TPA is going to do right by them? Because, of course, their job is being on the road, not necessarily knowing policies and procedures.
Right. Great point. So you've got a single driver, a single truck, and that's the company. They don't have a DER. So the regulations for owner operators actually allow the TPA to fall into the shoes of the DER and to put that owner operator in a random consortium and to provide guidance to that owner operator and potentially remove that owner operator from that safety sensitive position based on a positive drug test result and giving them the information to get into the substance abuse professional program.
So if you're an owner operator and you're removed, does that work?
That's why we have the clearinghouse. Right?
Okay. I was going to say, why if a DR or whatever you call it, TPA says you have to leave your job and I'm the owner operator, why would I leave?
For the past 5 years now, there's been the FMCSA clearinghouse.
Okay.
You go into that clearinghouse, you are in a prohibited status. And if you get pulled over, you might be going to jail.
Oh, wow. That's very
And
interesting.
also now when you go into that prohibited status, this just happened last November, they downgrade your driver's license. They take your CDL away.
Oh, so you lose your job. So you have
your CDL. So you
You're
can't
done.
work for yourself
It's over.
or anyone else. But you can go through the process, the return to duty process. You go through it, and then you have a return to duty drug test. It's negative. Now you get off the prohibited list. You go back down to the DMV and you get your license reinstated.
Okay, so I guess the key takeaway from this conversation is just don't do drugs, period.
You got it.
It's simple, and keep it simple and straightforward. Well, Joe, that's a great, thank you for coming on the show today.
Absolutely.
I really
Enjoyed
appreciate it.
very much.
Yeah, thank you very much. We'll have you back because I with the drug testing space, what I've learned today is it's very complex and it can get kind of convoluted.
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 We've got a lot of changes on the horizon.
Like a
We
cowboy.
covered a lot of topics. I mean, we could carve into one topic.
Oh my God, yeah. I'm already bored enough with drug testing, so it's a very interesting industry for sure. Well, thanks, Joe, for coming on again. We'll have you on for sure, and Andrew, thank you for coming on again this week. And obviously, stay tuned. We release episodes every Wednesday or Thursday. So I think this is our 9th episode, if I remember correctly.
Very cool.
So we're starting to improve our quality of the show, which is very exciting. All right, guys, thanks very much. Have a great day.
You got it.